In this session, we will talk about digital intellectual property rights. So let's take a look at some facts. The first question needs to be addressed is, do entertainers have the right to control who sees and hear a performance of their music? For example, this is a very typical scenario or occurrence in such concerts, for example, or performances. About 40% of software installed on personal computers worldwide and about 80% of software in China particularly was obtained illegally. Here you can see the piracy, status of countries, for example. As you see, these are the countries with major piracy. So the question again that has to be addressed here is, okay, is it fair for some people, like these people, to pay full price for software when so many others are getting the same program, same software for little or no money? So does that make sense? And as we see, half of teenage internet users in United States of America admit to downloading music files. They admit that they did it. And the Recording Industry Association of America identifies those file sharers and opens lawsuits against them, but usually they settle for $3,000 up to $5,000, depends on what they can get. And sometimes there has been some conflicts or problems. For example, this is a case from history where a Boston University graduate student, Joel Tannenbaum, didn't settle for this amount. Didn't agree on a fine or something, and he has been found guilty by downloading and sharing 30 songs and fined this much of fine, like almost $700,000 fine. And this trial has been held for almost 15 years, and it started with this much of settlement, and it progressed. You can read the details on Wikipedia. These are several songs that has been shared by him. So this is also another fact from United States. As Joel Tannenbaum has been fined this amount and has been found guilty, the Electronic Frontier Foundation runs a campaign which is called Let the Music Play to change the copyright laws. This is the claim that they are tired of being treated like a criminal for sharing music online. Come on, we're just listening to music or something. That's it. Why is this happening? Because creating the first copy on the digital platforms is very expensive, because you need to put lots of effort in it, but duplicates cost almost nothing. That's the issue. And if there has been a ideal global agreement on intellectual property rights as of now and goes fully into effect today, this is the scenario that can take place, and the added assets to countries here. So as we can see, United States will get the most benefit of it, and China will be harmed for maximum. But of course, such an agreement is far from being real for now. So what is intellectual property? Let's try to answer this question. It is any unique, of course there are many definitions, but it is any unique product of human intellect. Those can be books, songs, movies, paintings, inventions, chemical formulae, and of course computer programs. Here we do not mean the material that the intellectual property has been aligned with. Like when we mention about a book, we don't mention about the book as a material, the papers in it. So we're talking about the novel in it. So this is intellectual property, of course. And people have right to own property. It is a basic human right. We discussed this in chapter 4, I guess, session 4. But do they have the right to own intellectual property as well? That can be an interesting question. The complexities of digital property also needs to be addressed because there are even more problems if you discuss this property rights in the digital domain. It is coming from, the disputes are coming from mainly from the reproducibility property of IT configured societies, like we discussed this, I think, in chapter 3, because there is no notice from copying. So that's the case. And let's make some definitions here to proceed. What is a hardware, like the wires and the electronical cards of your computer, and what is a software? It is the, let's say, soft part, I mean not hardware part of your computer. So what is it? It is the algorithm. Okay, we know what an algorithm is. And the source is, let's say, it's the human read part of the computer program, and object is the computer read. Object code is the computer read part of the computer program, like the binary expressions in machine language, for example. And compilation of source results in object code. So this is what we know as definitions. So usually, in case of a dispute or in case of a, let's say, infringement, usually rival companies or rival counterparts target the algorithm here. Usually this is the thing has been targeted when there is an infringement. We shouldn't forget that software is still a new type of entity. We couldn't have an agreement on the definition of software, for example. And the internet is a very serious threat to copyright owners, and we're seeing case after case for infringements of copyright intellectual property rights of the software. So when you try to protect the property rights in software, there are uncertainty in many cases, because proprietary software could not be fit anywhere exactly like the books, for example. It's not easy to define them. And for that purpose, we have only 3 tools for protecting or for creating proprietary software and some kind of software property rights protection. This is copyright, trade secrecy, and software patents. Let's see all of them one by one. But you shouldn't forget that there is also another approach to this, property rights in software, which is called free and open source software movement. We will discuss it later. So what is copyrights? By definition, it is no reproduction without permission. So ideas cannot be copyrighted, but expressions of ideas can. That's the idea. And when we think about the software, expression, it corresponds to here maybe to object code or source code. And what is the idea here, which cannot be copyrighted? It is the algorithm. It's what it corresponds. So be careful, because ideas cannot be copyrighted and there is no protection on the algorithm. So when we consider what is the similarity between the idea and expression, it doesn't cover functionality or behavior here. We're just talking about, when we say the expression, object code or source code, we don't mean how it functions usually, because again, it's another gray area. And what is an infringement in this case? For example, replacing variable names. Is it an infringement? Could it be? And for the copyright owners, they have 5 principal rights here. So they have the right to reproduce the copyrighted work. They can distribute the copies of the work to public. They can display the copies of the work in public. They can also make displays, and they can perform the work in public as well. They have this right. And they can also produce new works driven from copyrighted work. These are the rights of the copyright owner. They can sell these rights, up to them. And for example, here is an example. Sell a license of a music, for example, or of a tune. Sell a license of a tune to a high school drama club, or you can ask for a fee from each broadcast on radios over some music organizations like MÜYAP in Turkey. So you can seek for each airing of your music. When there are infringements, the burden of proof is always on the copyright holder to prove the infringement. Why do we give this case as an example in the textbook? Because it's one of the significant milestones in history that that copyrights had been violated. This is the Franklin and Apple companies has been in clash here, and they figured that blocks of object codes are copied from Apple to Franklin here, and Franklin got out of business here in this case because of the fines. Because then we see many legal wars between Microsoft and Apple later. We still see, but even before 10 years before Microsoft, Apple has been in an infringement with Franklin computers of that time. If there is no striking resemblance, for example, if it is not that obvious, like object codes are directly copied here, copyright holder can try faking another's work versus building on another's work. No, they took my work. They didn't build on my work. So they also go for this, even if there is an obvious block copies like the previous case. In addition, they have to prove the need for proving access to programs, so that they didn't do those programs on their own. So this is pretty easy for marketed software. If you put your software on the market, you can say that, okay, those people accessed my program. It's very easy to defend. But however, if your program hasn't been put in market yet, it means that you need to prove that they have access to your program before it has been marketed. It is harder for internal issues. And digital rights management is another issue that preventing copying by software and hardware lacks. For example, what we see here today is when we buy a tune or an application in one of the platforms, it is not directly available on other platforms. So this is called digital rights management. And there are several tools for this. Of course, if there are several tools like this, hackers and users have become adept at thwarting such mechanisms. That's why in 1998, there has been they put a legal protection for digital rights management techniques, which is called the Digital Millennium Copyright Act. That has been accepted in USA, which is called DMCA. There has been a controversy on it, they're telling that digital rights management is not like copyright at all, because there is no year limit and violation sanctions has been put very heavy on this law. especially scientists were worried. Like, for example, in 2001, a Russian programmer Dmitry Skylarov arrested in United States after a conference, for example, just for why? Because he spoke about the digital rights management algorithms that they use. Maybe he just uncovered some maybe details of those algorithms and open issues maybe, and he had been held in prison for months. So this is a real case, and reverse engineering issue for integration is also important. I mean, in order to integrate your product, you need to do that, and that's why there's an objection against digital rights management tools, and especially for this particular law as well, because its sanctions are really heavy. Copyright is an industry relying on copyright protection laws. There are the copyright industries in USA are infamous. For example, the movie industry, music industry, and book publishing industry corresponds to 5% of United States gross domestic product, like over 500 billion in sales yearly, and 5 million approximately citizens work in these industries. They say that it is growing faster than United States economy itself, and foreign sales and exports of almost 100 billion results in making them the leading export sector of United States as of 2001. But I'm not sure about this, since it has been written in text. I'm not sure whether it is leading the export sector of United States. Maybe some weaponry or other industries can be of interest as well. But anyway, it's a huge industry. We can conclude that. This is again a case from history, where a dispute between Basic Books, the book companies, and the King of Graphics. University professors are contacted here, and they ask for the readings and courses, and packets of reading materials for students has been planned here. Like since I use only the 5 chapters of this book and 3 chapters from other book, and they just prepare course notes as books for the students here for particular courses. We also have such shops doing this in Turkey as well, and of course this has been called an infringement decision by the book against the book companies, and Kinko pays lots of money to 8 book publishers, and they get out of business in the end. Again, this is another case which is called the Davy Jones locker. Richard Kanadek was running a bulletin board system. Like, he's asking for $100 per year for subscribers, where he shares copies of more than 200 commercial programs. And he has been indicted for infringement in 1994, resulting in 6 months confinement and 2 years in probation. Why this is interesting? Because this is the first case in history about such a legal issue. And what else? How did the No Electronic Theft Act has been put into effect? In 1994, David LaMacchia, who was an MIT student at that time, posted copyrighted software on a bulletin board again in university computers, and users downloaded more than $2 million worth software in less than 2 months. But that case has dropped because he didn't profit at all. He didn't ask for money, as the case of Richard Kanadek. And this was called a loophole in the law system and fixed by No Electronic Theft Act legislation in 1997, where they call simply reproducing or distributing more than $1,000 worth of copyrighted software in a 6-month period would be called a criminal offense, so that they could be fined later. But of course, David LaMacchia survived since this has happened because of him. They say that copyright creep is threatening the chain of creativity and innovation at all. Where the Sonny Bono, and I guess he was a musician, he just applied for the Copyright Term Extension Act of 1998, and this law has been passed in American Congress as United States Congress as well. If the work has been published before 1978, there will be a copyright over author's lifetime plus 70 years after that as well. If the work is a work made for hire nature, like it's called WFH, so author owns the work, but the employee created the work, but the owner is the author. Here, after the publication time, they give you 95 years of copyright, and after the creation time, if you hadn't put in public, plus 120 years for copyrights. As you see how copyrights are put into effect here. At first it started with books, prints, sheet music, photographs, and all literary works, sound recording, motion pictures, and finally computer software. As you see, it's increasing and automatic renewals take place, and see, this is called the copyright creep. What is called the copyright creep? So many types of materials are being protected by copyrights, and it is causing a concern for people, which creates the chain of creativity and innovation. This is a discussion, open discussion. And another example, the famous "Happy Birthday to You" song, "Happy Birthday to You." Okay, it's in 1893, and it belongs to Clayton F. Summy Corporation. And then Time Warner Company bought this company, and it belongs to Time Warner now. The copyright, they copyrighted the song in 1935, and since then, television networks must pay Time Warner Company to air it in their commercial programs or something, and the Time Warner is earning about $2 million per year for this song, for example. That's it. And this is an important topic as well, fair use. So when it is fair use for copyrights and when it isn't fair, let's discuss about this. Okay, there are 4 criteria that you need to consider here. The first one is, what is the purpose of your using this copyrighted material without paying, for example, for getting the copyright? It can be either educational or commercial. If you're violating the copyright because of something commercial, it means that you would be in more trouble. But if it is for educational, okay, maybe that would be all right. And how about the nature of work that you violate the copyright? Is it fiction or non-fiction? If it is non-fiction, like you're talking about some scientific facts or some well-known fact, it means that okay, maybe it could. But if you're copying some fiction, like some art or a novel or something, or a music, for example, tune, it can get you in more trouble. Okay, more trouble. And how much of work is copied? You just copied a few parts of it or entire chapters. Of course, this one is more serious. And what about the effect on the market as well? Is it an out of print, or it is hard to access that material easily? I mean, for example, if it is out of print, or it is readily available that you can pay the price and get that book, for example. So again, if it is readily available, it is a more serious case. This is how we evaluate the conditions. For example, suppose that a professor takes some journal articles from library and then asks the students to prepare a homework or prepare a report from them, for example. And some students take them and the others complain, okay, sir, I mean, there were only 4 copies there and we're in trouble. I mean, how can we have access? Then the professor posts them in his own website with a password to the class, for example. Okay, he violated the copyright, of course, but Is it a fair use? Let's see. I mean, the first case, what was the purpose? It was educational. And what was the nature of work? It is, I mean, non-fiction, for example. Okay, suppose that it was a course about, because in logic, for example, logic design. And how much of work here he posted full chapters here, and that's the problem. And what about the effect on the market? Would the students go buy those journal papers? Not like not that. Wouldn't make sense maybe. So I think this could be also a question mark here. But okay, they say that it's out of print. So that's the case. Let's say. Okay, so here you see that, okay, since the positive sides are in favor here, you stay on the left side here, you can say that more or less it could be fair use. Otherwise, if you stay on the right side, it can be called an unfair use, for example. That's the idea. Let's look at the second one. Here, this time, he's an art professor. He just posts some photos from a reproduction book in slides, for example. Like, now this is an art. Again, the purpose is educational. You stay here. But now it's a fiction work. And it is, let's say, you're putting entire chapters here from it. And this one is, again, disputable, like whether it's readily available or out of print. But in any way, you can see that this one tends to more and staying on the right side, so you can say that this is a roughly unfair use here, since this one was about a bit fair and this one is a bit unfair. This is how you try to put some decision about or application of fair use practices. Okay, when does this how can you use this in real fair use? This was the case between Sony and Universal City Studios. You know this? Okay, they produce movies, still produce movies, very good ones. And the Sony is a very good company as well, well known. In 1975, they just created or developed first video recorders with time-shifting property. Okay. These devices are connected to your television, and you can set them to record at any given time. Unless, it doesn't mean that you can go ahead and sleep, or you can go to work and it will start recording between given times here. It's a very practical device of that time. However, when this has been started using by lots of people, widely used, Universal sued Sony for fair use violations. Why? Because people were not watching the movies, for example, in 10 p.m. or something. They were just sleeping and letting the device record the movie for themselves, and so it is making maybe drop in sales of tickets, or maybe people rent less movies. That's the problem, okay? So because they're creating many copies of the copyrighted material, that's the idea. So when we return to this, what was the purpose here? Okay, not educational, but personal use here, because it's obvious that those people are not selling those TV records. So we can say that we're here on the left side. And the nature of work, okay, these are fiction because these are movies, you see, that's art. And how much of work? Entire chapters. That is the case. Would that affect the market? That's the problem. Okay, and finally they concluded that it would not affect the market. Maybe, but as you see, the gray zone here. And the Supreme Court ruled 5-4 decision for fair use. Okay, fair use, and Sony prevailed here, and we had the ability. We had the option to have such devices at our homes while we record something and watch later. This has been made or deemed legal by this famous case. As we look at the details here, there are two types of fair use. Time-shifting fair use, since, it has been deemed legal here. This is called time-shifting. For example, you record it to your own device, and hold it and watch later, just for yourself. This is called fair use. However, if you record this here, make another copy of a copyrighted material, and cast it to public here, and even earn money maybe, so this is called not fair use. This is called time-shifting fair use. What else? And there is also space-shifting fair use for a product. Suppose that this is the original music, this is a compact disc, but here in this case, this is an old example, but I think it makes sense. You make a copy of it in your cassette player, like to listen to your in this device, and you make another one to listen it in your Walkman portable player, for example. So these are fair because you own this one and you want to have access to them in your other music devices as well, player devices as well. But if you make a copy and give it a copy for your friend, you can, yes, but be careful here. You can give this one, original one, to your friend for a while, or let him have it, that's the case, or he can give it back. Now, this is fair use. But however, if you make a copy of this one for your friend as well, it means that it is not fair use, So here you see the two applications of fair use for copyrighted material here. One of them is for time-shifting fair use, and the other one is for space-shifting fair use. And around the same time, peer-to-peer networks created much more trouble, especially for the universities. I've seen those ages, and they were using lots of file sharing tools for distributing or copying copyrighted material, and it was also causing legal problems. Although students were sharing the materials, it was causing problems for the universities as well. The next tool for software copyrights is trade secrecy. We can call this the second one. What was the first one? The copyright mechanism. What is trade secrecy here? That could be interesting. It is widely different, in fact. In general, it gives companies the right to keep certain kinds of information secret. Why do they do this? For supporting competitiveness between them. For example, Google keeping search engine algorithms secret. So that's giving them advantage. And for example, Coca-Cola formulation is secret as well. This is giving them advantage. And what can be kept secret, or what can be under the umbrella of trade secrecy? Here, the formulas, processes, proprietary designs, strategic plans, customer lists, and other collections of information. It can be anything. So in court, trade secrecy, if you want to mention about trade secrecy, you need to have these properties in that case. So whatever you're keeping secret must have some novelty. It should be something novel, something unique to you, and it should represent an economic investment to the claimant. You should show that I put some money for this, for developing this, and I have involved some effort in the development as well. I also put lots of effort for development, and the company also must show the efforts that they did to keep it secret as well. So the company should show their efforts for keeping it secret as well. What is the advantage here? They do not expire by any means, like copyright, or there is not an end to it. The Coca-Cola formula can be kept secret forever, or Google's search algorithms can be kept secret forever. This is the advantage. And what about the disadvantage? Confidentiality problem here. If you're marketing the software, it means that it is on the market and people are seeing it. So suppose that a movie, okay, when you, broadcast the movie, everyone will see it, and in that case, for example, if it is a program or something algorithm, it would be subject to reverse engineering. So for trade secrecy in softwares, the companies are putting non-disclosure clauses in contracts of employees, so they're forbidden to leak information, and licensing agreements for end users as well. No copying or revealing for employers, the software for employers, even after they leave the company, they resign or something. And customers are asked to not sell or give away their copies as well. This is written in the non-disclosure clauses. And there are other methods, software developers limiting access to programs, such that not giving users access to source program, for example, just the executable, or building identifier codes into programs so that illegal copies of the programs can be traced. Again, trade secrecy is applied or understood widely different in different places. Even in the same country, there can be some disputes, because there is no protection for taking general knowledge out of it at all. Some peoples are using web-based, server-based programs and apply remote working mechanisms, like web search engines work like that matter. What we call as software as a service applications, for example. Many games, computer games, are run like this in today's world. In fact, what you have here on your computers is just a client at all, because. So, what kind of copy you can make from it? It means that it's some kind of trade secrecy as well. And licensing agreements include the repairs and maintenance of software as well. Just you don't touch it, that's it. So it's limiting or minimizing the customer needs for source code as well. This is harder for shrink-wrapped software sold in mass quantities, but almost all of the software we use today are usually done as software as a service, but no more problem about it anymore. And for the bottom line, let's evaluate this as a conclusion. For trade secrecy to be licensed and used, some form of the software has to be often put in the public realm. So it means that when it is put in the public, it means that everyone will get an idea about your software. It's very easy to protect afterwards because of reverse engineering problems. We can conclude that it is a powerful yet impossible, or at least impractical, tool for software. It's not easy, we can say. But another method, of course, you can use it. And the last one is the patent protection here. It is the strongest form of protection, which results in a monopoly on the use of invention. It is usually for 20 years for software. It is the exact opposite of trade secret here. One needs detailed description of the invention so that you put it on public and you give all of its details and acquire a patent for this purpose. There are several kinds of patents, and here utility patents and design patents and plant forms. So you can have 3 types of patents here, and utility patents are usually in the category for software. Usually they are being given for 17 years plus 5 years extension if the conditions are met. Patent protection is for fostering an invention, invention and innovation. Okay, this is extra. I'm sorry, it shouldn't be here. For fostering invention and innovation. Rewarding is a means, but not an end from Kantian perspective as well. So you're rewarding people who are capable of inventing something. It's not bad about it. It's not bad at all. And sharing inventions in public realm is available with patent protection. So it's nice because it's encouraging invention, because you will get some financial benefit from it as well. And it is also inviting inventions to the public realm so that other people can benefit from it as well, because that people will earn money, the owner, and the others one will get the benefit of that, for example, medical drug or something like this. However, there is a restriction here: abstract ideas, mathematical formulae, scientific principles, laws of nature, and be careful, mental processes cannot be patented. Mental processes cannot be patented. Now comes the trouble for software. Let's see. For patent claim steps, I mean, in order to apply for a patent, there should be a permissible subject matter here, and that permissible subject matter must have utility. It must be useful for something. It must be unique, novel, and it must be non-obvious. What do we mean by non-obvious? Here is, it should be hard for common people to understand directly. It must be a bit complex, okay? So, in order to apply for a patent, you need to have these two steps. Now, this is, I think, pretty easy for software. They can have some benefit, they can be useful, they can be unique, and they can be non-obvious. Okay, computer programs are, I mean, pretty hard for common people still. Now, however, the problem is here, main problem here is about the permissible subject matter, okay? Because these cannot be patented. That's the idea. Subject matters, what can be the subject matters? A process, machine, manufacture, or composition of a matter or an improvement thereof. Software usually fits to a process or a part of a process here. Software can be this one. Now, of course, one of the students, one of you can ask me, teacher, don't you have a separate law, like software patent law or something, other than this traditional patent protection laws? No. I mean, if we had it, that would be great, but no. So we're bound to traditional patent laws here. That's the idea. That's the problem. That's an important problem that we need to address. Don't worry. And we can conclude what subject matter is transformed by software. Mental steps, are we transforming them? Or algorithms, mathematical algorithms, explicitly prohibited in patent law here. You cannot take a patent on them. So that's the problem. So this is a milestone in history between Diamond and Deere. These two companies had a dispute for this is the first time the execution of a physical process machine controlled by a running program was patentable. I forgot about the case. I don't remember the details, but you can look from the on the internet. Most probably, it was about a chemical chemical formulation software or something like this in a company. I forgot, but it has been a milestone that for the first time the court decided that the execution of a physical process controlled by a running program is patentable. So after this, there had been many patents. Like between 60s and 90s, there has been this much of patents, and after that, in 90s particularly, and they increased and increased and increased. Finally, as of 2015, 500,000 software patents in 23 different categories in United States alone. So, I mean, today even more, much more than this, because it's raising exponentially. That's the idea. For the patent protection, there are concerns about too much software patents are given nowadays, and building blocks of software are becoming proprietary with the help of those patents. This is a concern now, but be careful. it is not because of directly the diamond deer case here. I mean, because yes, it had an effect, but it is not the only thing, because there is lots and lots of work in software compared to 90s or 80s in today's world. That's why the patents are increasing as well. And here you see the companies with the most artificial intelligence patents, for example. Maybe it can take your interest, like as of 2018, like almost 100,000 patents per year as of patent applications per year as of 2018. As you see, Microsoft and IBM dominates the artificial intelligence patents here, and the other famous companies are following with, like Samsung, Qualcomm, Google, Philips, blah blah. Okay, these are all like the corporations who invest a lot in artificial intelligence studies or patents. So software developers need extensive and expensive research on patent search before putting something into market or before starting their project. This is putting a burden. If there are overlaps, those licenses must be secured. And since although there is no overlap, there are still risk of late issuing patents. Okay, if someone already applied since before you start developing your product, you can finish your product, but at the same time, those patents can be, let's say, accepted or approved. So again, you can get yourself in trouble. That's another problem of late issuing patents. And investment in cost of software development is much less than patent search, the effort you put in patent search, and again it is much less than if there is a problem, if there is an infringement, than the lawsuit cost. So as you see, maybe it's a discouraging environment for developing software. I mean, do you think so? I mean, for example, how about you start a startup business as soon as you graduate? I mean, are you getting discouraged about it? If you hear something like this, maybe yes, maybe not, but we can say that it is a serious barrier for small businesses currently. This is a significant case from history again between Polaroid and Kodak. Both are, let's say, big companies here. Kodak invented the first instant cam, which gives you your photo in like 1 minute. Like in a 1985 court decision, they found out that they agreed that Kodak infringed 7 of 10 patents of Polaroid in this case, and in 6 years Kodak paid almost $1 billion to Polaroid company and left this instant photography business. Of course, Kodak is today a great company, but is not operating in this, was not operating in that business for years in the end. Here you see some disputes between many famous companies of today's world. You see the smartphone competitor patent suits here. Everyone is, you see, like just opening case after case against each other. These are the legal cases between companies, disputes, or the wars, or say legal wars between the companies going on and on. And so this is only for the smartphone industry, and in the other technologies, of course, the fight goes on and on this patent laws. What else do we have here for protecting our digital intellectual products, like the trademarks and service marks, for example? Trademark is a word, symbol, picture, sound, color, or smell used by a business to identify their goods. And service mark is identifying service, the same manner, but just for identifying service. It gives the company a governmental right, a brand name, for example, like Aspirin, Xerox, Google, So the latter distinctive product is disadvantageous in this case if they use it. So they try to keep it up or distribute to public by or promote it by advertisements, of course. We should avoid usage of nouns and verbs and instead go for you promoting adjective use here. Could be interesting and you can use them like yo-yo, aspirin, thermos. In fact, they're just trademarks and service marks here. And brassiere, these are widely used, but in fact they're original names of some companies' productions. That's it. We have similar cases in Turkish as well. Just think about it. Like, okay, that's why they're promoting as adjective use, like salpak mendil. Yani, give me in Turkish here. Bana bir selpak verir misin? Aslında mendil veya jilet alıyorsun ama aslında jilet yani aslında bir ürün ismi veya bankamatik kartını versene. Bankamatiğe uğradım ama bankamatik İş Bankası'nın bir ATM'si. Aslında ATM diyeceğine o kadar alışmışız ki öyle diyoruz. Diğerlerinin adı farklı, diğer şeyi. Veya pimapen döşetmek, pimapen yaptırma, evi pimapen yaptırdım. Pimapen aslında bir şirketin doğramasının adı yani pimapen doğrama ama pimapen yaptırıyorlar gibi. Okay. So, for example, the people use it as a slang as well, like photoshopping images. Adobe Photoshop, for example, is a trademark, and slang uses are warned. But I can't say that they're unhappy with it because it is also undercover advertisement, very nice, viral advertisement. In fact, Adobe doesn't need to contact anyone before suing. It's protected by law at all because it's there. They own it, but people use it like, okay, photoshopping, okay, it's a photoshopped image or something, and it's very common slang between users. Okay, now, until now, we talked about proprietary software. What else? Okay, there is an alternative for this, which is called free and open source software, which has two tracks here. One of them is, we're talking about two tracks here. The first one is what we discussed already, and the second one is the software produced and distributed under free and open source software categories. And there is transparency of software here. Everything is open and open for user customization. You see how different this approach is from this one. This one is protected by copyrights, trade secrecy, and patents, and this one is open for everyone. But how can this happen? So Richard Stallman and many others have some criticisms of this proprietary software today. Like he says that, Richard Stallman says that copyright systems designed in an era where copywriting was hard and digital technology made copying trivial now today, leading to harsh measures and leading to infringement on even our liberties as well. He's just criticizing the current proprietary software environment today. And copyright system bases should promote progress such that not making authors wealthy and more wealthy. He argues about this, and he argues that copyrights are not promoting progress in software currently. He argues about that, and we can say that owning intellectual property is like the owning and being friends, like sharing between friends the information to get better and better. He argues that cooperation is more important than copyright by means of creativity. Okay, this is an argument. And this leads to, or this idea shared by many experts in industry led to open source software movement. This is called open source software movement. And freedom of software, free and open source software encourages users to run, redistribute, and modify the code. And there are also restrictions on the reuse of the code, but this is the basic idea. I mean, they can run, redistribute, and modify the code as well, which is quite different. There are three important approaches to digital sharing, okay? Like we share to get better. One of them is free software, the other one is open source software, and the last one is the Creative Commons. Let's see what are they. Okay, the first one is free software, where users are allowed to run, copy, distribute, study, change, and improve the software. It is driven by the Free Software Foundation, which is called FSF. And the key is, the only thing you need to be careful is, when a free software is licensed by GPL, the code incorporated to another program is also have to be free software as well. This is why they call it like a copyleft scheme, like it is spreading, and it is a viral scheme that free quality of code infects whatever code it touches. That's the idea. And what is open source software? Here you see again many examples of popular applications here. It is driven by the Open Source Initiative, OSI, and it has no restrictions like free software. It is not licensed with general public license as well. Okay. And in fact, open source software was a success story. Success story is coming from GNU. What is GNU? Is not Unix. Okay, that's the project, and it leads to Linux operating system. Linux is an Unix-like operating system consisting entirely of open source software. Many people contributed to this, maybe hundreds or thousands, but these are the famous people. Richard Stallman created the most of the necessary components, and Donald Knuth, this professor, famous professor, made the text typesetting system, where Massachusetts Institute of Technology developed the X Window system, and the famous Linus Torvalds was the responsible of the kernel of Linux. And this is an article from journalist Andrew Leonard in 1998. He says that, this is his word, this is his comment. Linux is very subversive. Who could have thought even 5 years ago that a world-class operating system, Microsoft, coalesced as if by magic out of part-time hacking by several thousands of developers scattered all over the planet, connected only by tenuous strands of the internet. So that was the case, in fact. So it was a revolution of some kind. And finally, Linux put hard pressure on Unix. I think then they failed, and they had put serious pressure on Microsoft and Apple too. They were just the defenders of proprietary software, because even popular retailers started selling Linux equipped PCs for $300 or something, which makes people started buying them instead of buying computers with readily available Windows or Apple operating systems. That's why. In 2002, for example, 90% of the operating systems on the world was still Microsoft, but they an email sent to senior managers to hold on to government and large institutions at all costs. You do everything you can not to lose the ground. And they have been given even special funding, leading to large discounts for government and large institutions. Even for free, they distribute their operating system. The idea is, under no circumstance, lose against Linux. So it can be because it can be the fall of proprietary software idea. That's the idea. There is a critic of the open source software, of course. If critical mass of developers do not contribute, software quality becomes poor. If no one contributes, then what else you can have? And there are other ones. And here, what is the owner here? Okay, who is responsible? That can be a harmonization problem, because several groups working separately leading to incompatibility between the versions. But in fact, this never happened. We can say that in the years. Still about 99% of Linux distributions have the same source code around. And another criticism is they usually have weak graphical user interface, leading to less user-friendly atmosphere for end users. Is that the case? Just think about it. That's why I put a question mark here. Resulting in preferred more on servers rather than end users desktop. But I don't know. I looked at the last versions and they're pretty user-friendly, I think. And another criticism, is that so? Discuss about it. Think about it. They say that there is a poor mechanism for innovation in free and open source software, because open source software lacks innovation. They only duplicate what has been invented at all. Like, okay, what is LibreOffice, for example, or the Open Office, for example. It is just imitating what Microsoft Office is doing, for example. They never implemented anything new. That's another criticism, up to you, open for discussion. Okay, and the next one is the Creative Commons. There is a need for an alternative system. Like this is the case that we're just experiencing. It's fine if you use this photograph, as long as you give me the credit for taking it. I mean, for God's sake, I mean, we're on the internet. It's pretty hard for me to hide it, but if you use it, please mention about my name at all. Tell me that it belongs to me. So Lawrence Hessig, Hal Abelson, James Boyle, and Eric Eldred and Eric Saltzman in 2001 gathered together, and they claimed that there is a benefit to the resources held in common, and the internet is the best evidence of that benefit. So they created Creative Commons for protecting digital intellectual property in this way, in creativity. So this is the steps that you need to protect your original photo. You taken a photo, go to creativecommons.org and answer 2 questions. Are you going to allow commercial uses of your work? You want this or not? And are you going to allow modifications of your work? Yes, no, or yes, you can do it, but as long as others are sharing it alike, okay? So the website creates an HTML code with proper Creative Commons license that you can paste and use for yourself. And as of 2008, 130 million different Creative Commons licenses held on intellectual property, and as of 2009, it was the printable content license for Wikipedia as well. And today it's again quite popular. And this is okay. How you? You see the symbols here. Like if you want to use it commercially, and like whatever you allow here, it will create a code for this purpose. Again, another approach to digital intellectual property and free and open source software movement side, rather than proprietary part. In free and open source software, there is a common misconception where they say that there is no distribution cost. In fact, people still make money from distribution and customizing free and open source software. Here, the main distinguishment from proprietary software is the right to view and modify the source code. And several big businesses are into this as well, like corporations such as Sun. Now it belongs to Oracle, and IBM, and even also Microsoft are in this business. I think IBM has been bought by Lenovo. I guess. I think IBM has been bought by Lenovo too. And internet dramatically helped free and open source software movement. This is obvious. It was harder before, and it is easier now. And freedom of software, free and open source software represent a threat to proprietary software branch, and they have been accused of being illegal and communistic in today's community. And major corporations and small businesses are into free and open source software as well, where they make money by providing customization and maintenance services at all. Now let's go ahead and let's discuss the philosophical basis of property, okay? So far we have seen the proprietary software tools and free and open source software approaches, and let's discuss which one. Okay, now you may get confused, that's okay, but let's go back and define. What is property? What can or cannot be owned as based on laws? Different topics require different rule sets. For example, land and automobile, owning a land or automobile have different properties, of course. This is the same for software as well. It would be different. And ownership of intellectual property gets very complicated in this sense. And patent and copyright law, utilitarian, in fact, fostering creativity, innovation, and encouraging disclosure of inventions. But it is often defended as a matter of natural right as well. It is loosely connected with Kantian and John Locke's labor theory as well. Let's take a look at natural rights argument of John Locke's labor theory. Individuals own themselves, so they own their labor as well, okay? Otherwise, they would be slaves. And individuals have a natural right to what they produce with their labor. This is the core of John Locke's labor theory of property. That's the idea. And here, if someone violates those laws, it means that, for example, making those people their slaves. Suppose that these farmers are raising these crops and perhaps they will just store them, eat them, or sell them later. But if someone comes and steals them, it means that that person who steals them is turning them into slaves other than farmers now, because they're using it for their own benefits. Is that the case for software as well? That's the question. So, do you think natural rights argument hold here? It is appealing, but not flawless. Why? Because of the nature of software. Here's an argument by Nozick in 1974 when he discusses property and labor. What happens if you mix your labor with something else? Suppose that you pour your tomato juice into a lake, and can you say that the lake is mine now? You can make an analogy to free and open source software's viral scheme here, because many people are contributing there. Now, the debate of a no property rights society is not unjust with respect to natural rights perspective as well. I mean, we're trying to be just here. It is not unjust at all if you don't have, if you think the other way. And the second one is against the natural rights argument. Again, software is a non-tangible intellectual property, because you cannot hold it. You cannot put it somewhere. It's an intellectual property where you have unlimited resources, in fact, and no confiscation is possible here. I mean, when someone steals your software, you still have a copy for yourself. So again, it's complicated. How about ideas? Okay, for crops, that's okay. It means that there is confiscation here. How about ideas, musical tunes, and mental steps? Like if someone steals it, you still have it. What is the problem here? That's the important question. What is the problem here? Think about it. Pause the video and think about it for a while. What is the problem here? The problem here, the main problem here is, the proprietary software developers want to control software for their economic gain in market environment. Okay, we go to finance here, we go to money here. They want an economic right? So it's about the environment here. And by means of economic right, proprietary software defenders and free and open source software defenders both want economic benefits, but they both have different visions for that purpose. That's the problem. That's the main problem. Now, this should be your debate focus. Come on. think about it and make a debate on it on your own or between your friends. Which system is best for the production and distribution of software? What do we mean here? Which system will lead to best consequences? Which system will lead to most robust environment software developments? Which approach would be best for software creation? Which approach would result in widely accessibility? Which system does these? Which would be more beneficial for society, for future of humanity, for example? You can discuss this. That's an important debate focus. And there is a natural rights argument against software ownership here, where the patent law, the doctrine of mental steps are interfering with the freedom of thought, because there is a dispute here all the time. Because what are you patenting here? What are you putting copyright here? Are you putting on the algorithm or something? Okay, you're limiting my creativity then. In this legal environment, free and open source software creates such an extension here, suggests such an extension here. Look at this. This is my belief here. Either you need to create a new patent laws, new copyright laws for particularly software, or otherwise this is a problem. Interference is a problem in today's world, and free and open source software is creating an alternative in this environment. It is not implausible, but increasing artificial agents and expert systems open up a new frontier as well. On the other hand, this has been discussed by many researchers, like I think Deborah Johnson as well. One should be careful about legal status of machines that think in future, able to think. That's another issue. When you think about proprietary software versus free and open source software, best system results in best consequence. In proprietary software, they say that there is no motivation without protection. Okay, well, if I don't make money from this, I will get out of business. I will go farming, or I will just deal with something else. I will leave this business, they say. And free and open source system relies on a credit system, maybe together, something like rep, maybe. So people are crediting each other, or they do it willingly. That's the idea. A credit or doing this willingly may not be enough motivation factor for everyone, but free and open source software, let's say, volunteers demonstrated that making money is not the only incentive for software development. This is very important. They do this for art, they do this for hobby, they do this as they like it. It's very interesting. Okay, and utilitarian approach results for seeks the best consequence in evaluating, analyzing scenarios. So is this right or wrong here? We should go for the best consequence. So we can conclude that this is an unfinished debate, and both ways, can we say that we're lucky today that both ways can be analyzed easily at the moment? I mean, okay, we have both of this going concurrently in parallel, proprietary software and free and open software going together today in our current world we live in. So let's come to an interesting question. Is it wrong to copy proprietary software? Let's get back to reality. Today there are many illegally protected proprietary software. Now this question is important. Is breaking proprietary software or free software rules wrong? Can you break them? I mean, would it be fair? Usually, backup copying is generally not illegal. Though not universally accepted, there are a few exceptions, but that's okay. And individual issue can extend to collective level in companies. For example, sometimes companies buy multiple copy licenses for their workers with a discount, for example. Okay, in that case, copying is okay. But there is a quite common phenomenon in general. Individuals who would not break other laws will make illegal copies of software. Why are they doing this? Why are they doing this? Think about it. Think about it. Okay? Just pause the video and think about it for a while. The reasons aren't important here. We should focus on the immorality and defend these two claims. And nothing intrinsically wrong in copying, or copying does no harm. Can you go ahead and defend this? That they're not immoral? That's the question. That would be both okay if copying weren't illegal in this case, in our world, in reality, in today's world, okay? And once legalized, if there is a legal scheme like this here, now deprivation is considered, okay? Someone will have it, the people who pay will have it, and the others will not. This is the same scheme for free software as well. You cannot say that, okay, I'm not agreeing with your copyleft scheme, for example. You cannot say that for free software as well. That's the idea. And it is immoral to do something illegal for this particular case here, okay? Because we are doing something illegal if we are violating by copying proprietary software here. That's the idea. So here you can go for a counter argument where you say it is permissible to break any law one deems not good. Is that so? Is that so? Any law? If you don't agree with the law, you can go ahead and break it. Now we shouldn't forget that we have a prima facie, I cannot pronounce it right, but we by default, all else being equal, and unless there are over reasons, we need to obey the law. There is an obligation for this because we live in a society, right? Remember this from chapter 2. Okay, we live in a society. Unless there are overriding reasons, we need to obey the law. If we accept that we are all equal. If you're not accepting that we are, okay, if I say that I'm a unique person and I have more rights than anybody else, okay, then you can close this lecture and go ahead and do whatever you like. That's the idea. So anyway, what is the overriding reason in this case? Think about it. Think about it. For copying proprietary software. What is the overriding reason in this case for breaking the law? Pause the video and think about it. Think about it. Okay. What you're doing is copying proprietary software, especially even when there is a freedom of open source, free and open source alternative as well. This leads to civil disobedience. It can all be, although corresponded or related would be to disobedience as well. In order to do this, you have to rationalize this following. Universally, this is wrong. Proprietary software is wrong. Show this, please. You need to show this. Show that the system of property rights is not just a bad system, also an unjust system. Okay, and adhering to those laws compels you to perform immoral acts or support unjust institutions. If you can show this, then go ahead and break the rules and make copies of proprietary software. But be careful. One is very hard, this one is very hard. Okay, and it is connected. The second one is connected to this one. Okay, there is a between that. One is very hard. You can go for example, oops, I'm sorry. This one should be EG. For example, you can say that Microsoft is becoming a monopoly. If you can prove this, or if you can prove that Apple has created a monopoly, for example, or big corporations are becoming a monopoly, okay, you can go ahead. Then you can prove that 2 is plausible. However, whatever the case is, mostly software owners' claims are much stronger today than proprietary software copiers. Why? Because especially if there is a free and open source software alternative, don't forget about it. You can just, extend this to music and movies as well, because perfect copying is easier with web. It has not been possible before. I mean, before technology or before internet, especially copying took a lot of effort to make copy. We should address this. And by 2000, Napster was an infamous peer-to-peer music sharing system. In fact, it was an information technology invention, and it was very successful for bypassing the current copyright system of that time. Of course, it has been then and closed, but it was a pioneer. It means that, then you go ahead and with the pioneer approach here, there has been alternatives, which resulted in contact-free bands, so that music could become, let's say, more free. We can say that. Okay, we should maybe address or underline that no rules is not possible. Okay, no rules. A no-rules society is impossible. Let's accept this. It would be anarchy, right? I mean, we discussed in maybe chapter 2, right? A no-rules society is impossible. We will only have, but instead of old rules, we can have new rules, advanced rules, like Creative Commons, for example, one of them. I mean, new rules are possible. For example, this is the same for music as well. Now people are distributing there are many famous musicians with like millions of thousands of subscribers, and they're making lots of money. They're putting uploading their art, uploading their tunes into YouTube, SoundCloud, Vimeo, and promoting their business. So how were they doing it before? By the music companies, right? Like which ones? EMI, for example, a music company. Roadrunner Records, Roadrunner. Like those were the middlemen before. In order to publish your music, you need to have an agreement with a company. Now the middleman is eliminated. In fact, long live the middle thing, the internet. The internet platform would be your middle thing. That's the idea about the new rules. Okay. And bottom line, new systems are on the rise. Okay, and there are two creative responses to weaknesses in traditional ideas, traditional systems, which is freedom of free and open source software and Creative Commons. We can say that these are alternatives for traditional digital intellectual property protection systems. This was all about this session, and here are my references, and the Google Images is where I took all the images from. Thanks.